Thanks, Judge Hardigan. Thanks so much. And while we're on the topic of veterans, my dad served in Europe in World War II, and I've always been very, very proud of that. And it wasn't an easy experience, but he served his country well. So thank you for all that you men and women have done for us. It's really appreciated. That's an understatement. I can't put into words how much it's appreciated. So thank you. So it's a real, real privilege for me to be here. Um, Derek and Shannon, thanks for thinking of this and for inviting me to do this. And of course, Emily and Harlan, thank you for all you do so that this all works out. We had a little bit of excitement getting the technology up and running, but I think it's going to work from here on out. So yeah, Judge Hardigan summed it up pretty well. I'm going to give you um, some information tonight on wills and trusts and estate planning. We'll start with a conversation about wills. I want to convince you what Judge Hardigan just said, that every adult should have at least a will. We're going to talk about what happens if you don't have a will, and just the importance of having a will. My main goal is to convince you of that you need to have at least a will. But I'll go beyond wills. I'm going to talk about trusts. I'm going to spend some time talking about something that many of you may already have called a revocable living trust and how that works. It's kind of an alternative to having just a will. So we'll talk about that. We'll talk about a couple of other different types of trusts, the life insurance trusts and support trusts, and charitable remainder trusts briefly at the end of the seminar. We'll talk briefly about life insurance. We are going to talk a little bit about taxes, briefly about income taxes, but I'm going to spend some time introducing the gift and estate tax to you. A lot of people kind of understand the income tax, but are hazy about how gift taxes and estate taxes work. So we'll spend some time on that. Talk about living wills and durable powers of attorney for healthcare, something that you should think about when you're putting together your will and your estate plan. And we will talk about the possibility, if it makes sense for your family, of putting uh, organizations, good charities in your estate plan, like DePaul, like veterans organizations, and how to do so, and maybe even have um, Uncle Sam chip in part of your gift, those charities. So we'll just talk about a couple of techniques there towards the end of the seminar. But like I said, my main goal is to convince you that you need to have an estate plan. You need to have at least a will. And even if you have a will, you want to make sure it's adequate and up to date. And my favorite example of somebody who did have a will, but it wasn't terribly adequate, is oh gosh, it's not going forward here. Let's see. Um, Oh, it went, okay, just a little slow. My favorite example of someone who had a will, but it wasn't terribly adequate, is Chief Justice Warren Burger. People my age and older should remember that name. He was the Chief Justice of the Supreme Court, and he did have a will, but it was kind of a sad example of a will. A couple of problems with it. It wasn't witnessed properly. It didn't give his executors the powers they needed to do things like sell his property. Worst of all, it did nothing to minimize taxes, and his estate, between Virginia taxes and federal taxes, paid almost a $500,000 in estate taxes. And had he done a plan, they interview a lawyer in this article who said, had he done a plan, an estate plan, he could have eliminated all those taxes. So $500,000 of taxes that his estate did not need to pay. And they asked the lawyer in this article, now this is from 1995, which shows you how long I've been doing this, but they asked the lawyer, how much would you have charged him to put together that estate plan that would have saved him $450,000? And the lawyer said about $2,000. Now, $2,000 is a lot of money. I think hard before I spend $2,000, but a $2,000 lawyer bill to save a $450,000 tax bill would have been one of the better investments he ever made. So, so yeah, you need to have a will, and you need to make sure it's an adequate will and it's up to date. So what I do to get this conversation started is a little estate planning test that you can take in your head as I go along. True or false? I have a will. So if you don't have a will yet, I'm really glad you're here. Because you're interested, and we'll get you started. But every estate plan starts with a will, no matter how simple or how complicated. Every estate plan starts with a will. Question number two, My immediate survivors know where to find my estate planning documents. Very, very important to have your estate planning documents in a secure place and let one, two, three, four people know where they are for when the time comes. And the reason for that is uh, the originals are very important in Illinois, and I'm sure other states. They need to be able to find the original of your will, not a photocopy. It's very hard to prove a photocopy of a will. So where are some good places to keep your original documents? Well, the safe deposit box is what everybody used to use at a bank, and you can still do that. I have one of those fireproof boxes at my house. And again, my spouse knows where it is, but my brother knows where it is, and a couple of other important people. So keep your documents in a safe place and let somebody know where they are. My executor and alternate executor are still capable and qualified to serve. Now, if you have a revocable living trust, which we'll talk about in a little while, the role of the executor is got a different title. You call that your successor trustee of your revocable living trust. But let's talk about what an executor of a will or a trustee of a revocable living trust. Is anybody else hearing that feedback? It seemed to have stopped. Let's talk about what an executor of a will or a trustee of a revocable living trust do after someone passes away. There's three jobs of an executor. The first thing they do is marshal the assets of the estate. They pull together everything the deceased person owned. The second job is they pay the debts of the estate. They pay everything the deceased person owed. And the third job is they distribute the estate as laid out in the will. So it sounds fairly simple when I talk about it that way. But think about all the things an executor might have to do. They're going to have to file a final tax return for the individual. And so they'll need some access to their documents and their what is it, the W-4s or whatever it is you get, 1099s and things like that at the beginning of the year. They might have to sell property. They're going to have to open a probate estate in some cases, which they'd hire a lawyer to help them with that. So what I'm trying to say is it's not necessarily a simple job. Now, it's not an impossible job either. Basically, you want to pick, before you go see a lawyer, you want to have in mind at least two people, and better off three people, your first choice, your second choice, your third choice for the job of your executor. Or if you have a living trust, your successor trustee. And that's something you need to think about every few years. Is my executor still the right person to do that job? So again, you just need somebody who's organized and someone who stays on top of things. Question number 4. My guardian and alternate guardian are still capable and qualified to serve. I'll talk a lot tonight about money and taxes and all that stuff that involves your will. But the most important thing your will allows you to do is nominate a guardian for your children or other vulnerable family members like adult children with disabilities, or sometimes we have to assume a guardianship later in life over an elderly parent, an elderly spouse. And your will is your opportunity to nominate a guardian for those most vulnerable family members. So if you have a situation like that where you have minor children or you have adults with a disability and you're the guardian, you really have to have a will because it's your opportunity to nominate a guardian for those people. And again, similar to the executor, you want to have a first choice in mind and at least one second choice in mind for guardian. Number 5, my executor is knowledgeable in these matters and knows how to find the necessary information to settle my estate. Well, I said that your first two jobs of your executor are to pull together everything that you own and then pay all that you owe. Wouldn't it be helpful if your executor had some idea of what you own and what you owe? And the answer is, yeah, it certainly would be. How do I get that information over to them? Well, one way to do it is I have this document for you, and I'll tell you at the end of the seminar how you can get your very own copy. It's called, I call it an estate inventory. And it's basically just that. It's a list of your assets and liabilities, a list of what you own and what you owe. And the main purpose of the estate inventory is you fill it out before you go see a lawyer. And then your lawyer will be very interested in the information in your estate inventory. They're not only going to be interested in what you own, but how do you own it? Do you own it inside those mutual funds, inside an IRA or a retirement plan? Do you own the property jointly? That's all in your estate inventory. And then there's a place to list, what you owe and account numbers and things like that. And again, that's very helpful when you're planning your estate. But one piece of advice is to, when you're done with your estate plan and you have your estate planning documents, paperclip your estate inventory to those documents. And then every year or so, when you go over your documents, which I'm going to suggest that you do, update your estate inventory. And when the time comes and someone has to use those documents, they not only find your will and maybe your trust, but they find an updated estate inventory with updated information about what you own and what you owe. The idea here is to make things easy on those who have to settle our affairs. All right, continuing along. Number 6, my attorney has offered to review my estate plan to make sure it's in compliance with recent tax laws. The idea here is, and this one and the next question, is you can't do your estate plan once and then forget about it forever. You need to make sure it's up to date with the law. And another thing you need to make sure is that it's up to date with your family situation. Number 7 is my survivor's financial needs have been reviewed and appropriate steps have been taken to meet them. So if you have a 20-year-old estate plan, is that still where you want the money to go? You might be leaving money to people who are no longer alive or no longer need the money. So what I suggest is that you go over your estate plan once a year and think about these questions. Is it up to date? Is it still doing what I want it to do? What I do, I still get a calendar for my wall. I write down all my family's birthdays and anniversaries every time I get my wall calendar in early January. I wait till after New Year's because they're 75% off if you wait. And I write down all those family birthdays. For me, that's a big task because I happen to be the youngest of my parents' 12 children. I wonder if anybody on the call has me beat in that category. Not too many people do. I have 11 siblings. My mother told me always to bring that up. Tell people you're the youngest of 12, so I slip it in there. Anyway, long story short is when I'm filling out my calendar, I put in November on a Sunday, read your will, and I go over my will and estate planning documents once a year. Sometimes I don't even pull them out of the box. I just think about them to make sure that at least once a year I'm putting some thought into this. And if you ever move out of whatever state you did your estate plan in, please have your documents reviewed by a lawyer in that state to make sure that they are up to snuff under the laws in that state. Number 8, the financial benefits for any minor children named in my estate will be provided for in a trust. So if you have minor children and you're putting together a plan, you not only have to think about guardians, you also want to think about trustees because you're not going to leave a whole bunch of money to little kids outright. You're going to leave it to them in a trust for their benefit, and you're going to have adults manage that money. Now, often the same people you will choose as the guardian for the children will also be the trustee of the money you've left for them, but not all the time. Sometimes it might be a good idea to have one sibling as the guardian and another sibling managing the money. It all depends upon your situation. So that's called a support trust. When you leave money in a trust and have someone else manage it for the benefit of that person, because that is a better plan than having that person manage it. Number 9, my survivors have been briefed regarding key people they can consult with in decision-making situations. Again, that's information you can put in your estate inventory, your lawyer's name, any financial planner you work with, your tax person. That would be helpful for your executor to know when they have to wrap up your affairs when that time comes. Finally, number 10, after family needs have been met, I've considered sharing my estate with important charities that have touched my life and I see doing good in the world. I always say your estate plan is a stack of legal paper, but it's more than that, right? It's a reflection of your values and what you cared about in your life. And for most of us, that means family comes first, and that's as it should be. But also for most of us, we take care of charities that we see having an important impact in the world during our life, and that's a value that can be carried over into our estate plan. Like I say, family comes first, but a lot of people will leave an appropriate percentage of their estate to charity after taking care of family. And that's always a good way to do it, because if you leave a percentage, you know you're not going to leave too much or too little. That percentage, that amount will grow or shrink depending on what's going on with your assets as they grow and shrink. So you'll never accidentally leave an inordinate amount to charity. So that's your estate planning test. If you had a lot of falses, that means you probably haven't gotten started yet, or you need to take a closer look at your estate plan, which is fine. That's why we're here. Um, but you know, the important thing is that you know that it's important to have a will, to have some sort of estate plan. So let's follow this outline. I call it estate planning considerations. Again, I'm going to sound like a broken record, but the first estate planning consideration is your will. Every adult needs a will. Every estate plan has a will. But a lot of estate plans also incorporate trusts. So I thought I'd take some time to talk about how trusts work. And the way I do this is I say there's 5 parts to any trust, okay? So let's just talk about trusts in general, and then I'll talk about, for a while, about revocable living trusts. So first thing you have when you have a trust, you have a person, and that person has some assets. And that person decides to transfer those assets out of their own name into a trust. Then that person will nominate a trustee to manage the assets in that trust. So they will no longer legally own those assets. Those assets will be placed in trust, and they will have a trust document that gives powers to a trustee to manage those assets. And that trust document will instruct the trustee to make certain payments for a certain period of time to certain individuals, payment beneficiaries. So a trust might say, pay John a certain amount every year for the rest of John's life, or pay Mary everything she needs for her health, education, and support until she reaches the age of 25. The point is, whatever those payments are, it'll have a period where those payments are made, and at some point that period will come to an end. The individual's life will end, or the period of time will end, and at that point the trust itself will wrap up, and whatever remains in the trust will be paid once and for all to remainder beneficiaries that were named when I set up the trust. So let's talk about how revocable living trusts work, just to put some meat around this skeleton. So suppose I decided I wanted to do a revocable living trust for estate planning purposes. Here's what I would do. I would take everything that I could, change the legal title on that asset out of my own name and into the name of the Rich Goode Revocable Living Trust. So technically, legally, I would no longer own my own property. That sounds kind of weird. Here's why it's not weird. I'm going to name myself the trustee of the Rich Goode Revocable Living Trust. And that trust document's going to give me, Rich Goode, the ability to use that money any way I want. And I'm going to be the payment beneficiary of the Rich Goode Revocable Living Trust. So basically, the money in the trust is just going to be like it was before I changed it out of my own name. In fact, the trust won't need to get its own tax ID number for that reason. It will just share my tax ID number while I'm alive. And any income tax results that come out of that trust, I'll just report that on my own tax return. And so during my life, it'll be very little difference to owning that property in my own name. Here's where the big difference comes. At the end of my life, that property in that trust will not pass through my will because it's not property owned by me. Where will that property go at the end of my life? It'll go to the remainder beneficiaries that I put in the trust when I started my trust. So the same people that I would have named legatees under my will are the remainder beneficiaries of my revocable living trust, and my trust does what my will would have done. It passes my assets on at the end of my life. So you can talk about the living trust as if it's a will substitute. Why did I say, though, that you still need a will even if you have a revocable living trust? What you will have is something called a pour-over will, and it's just for anything you forgot to title in your trust. So if I left something out of my trust, my pour-over will say, I, Rich Goode, leave whatever assets I still own in my own name to the Rich Goode Revocable Living Trust. So things like my car, I don't generally put that in my trust. I own that in my own name. But there might be a stray bank account or something that I forgot to put in my trust that will pour over into my trust. And trusts work great. I did a trust for my dad right at the end of his life, and it works great. Why would you do a trust and not just a will? A couple of reasons that people do trusts. One of the reasons I did it for my dad was disability planning. My dad had Alzheimer's disease. Had he lived longer, he might have needed some help in managing his assets. So we set it up that my brother could step in while he was still alive and be his successor trustee if he became incompetent. That never ended up happening. But disability planning, you can do disability planning with a will and a power of attorney for property as well, but maybe it's a little cleaner with the trust. I thought so, so that's why I did a trust for my dad. Another reason people do a revocable living trust is that if you structure it right and you get all your assets transferred into it, the estate won't have to go through probate. As long as whatever remains outside the trust is less than $100,000 in Illinois, the pour over will can pour it in the trust and probate will not be required. So the question becomes, well, okay, how big a deal is probate? And I want to walk a little bit of a thin line here. Avoiding probate's a good thing. Why not avoid probate? But I don't want anyone here to think probate's the end of the world either. If you have just a will, your will probably go through probate, but that's probably not a big deal. For most people with simple estate plans, probate involves two quick appearances before a judge, one to open the estate and one to close the estate. Then the estate goes through independent administration. There's less than $1,000 in fees for probate. It's really not a big deal. And so you can go to these seminars where they put the fear of God in you about probate. And I guess I don't agree with that. Probate for most people is not the end of the world. But trusts help you avoid probate, and that's not a bad thing either. Lastly, we're going to talk a little bit about estate taxes. If you have an estate tax issue, you're a lucky person because it means you have millions of dollars. And if you have to do estate tax planning, you're definitely going to use trusts to do that. So that's a definite one. If you have tax planning to do, you are going to need a living trust. So my conclusion here is that living trusts are great, but if you have a will and it's an adequate will, that can be okay too. There's seminars about living trusts where they push them really, really hard. And you'll go to cocktail parties and someone will tell you how you're crazy if you don't have a trust. I don't agree with that. Trusts are great, but wills can be okay for a lot of people too. But that's how the revocable living trust works. Again, a lot of you may already have one. They're a little more expensive to set up. They're a little more trouble to set up. You have to change the deed on your house into your trust and change all your accounts into your trust. But it might be worth it depending on your situation. So we'll come back and talk about a couple of other trusts in a little while. A little bit about life insurance. I wouldn't put myself forth as the foremost expert on life insurance, but I have a lot of life insurance right now because I have minor children that I haven't yet put through college. I imagine once I get them launched, I'll let those, I have term policies, I'll let those lapse. One thing I want you to know about life insurance, we're going to talk in a minute about estate taxes. Life insurance can be part of your estate for estate tax purposes if you own the policy. If you don't own the policy, it wouldn't be part of your estate for estate tax purposes, and that can be important. So let's talk about it. Let's talk about estate and gift taxes. And basically, estate and gift taxes are taxes on transfers of wealth. And they're kind of the mirror image in some ways of the income tax. If you think about income tax, when I earn money, when I take money in, it's taxable to me. And it's the earner, the receiver of the money that pays income taxes, right? Well, estate taxes are kind of the mirror image of that. When I'm giving money away, that's going to be taxed. And it's the giver, not the receiver of the money, that pays estate and gift taxes. So they're really taxes on transfers of wealth or transfer taxes. So let's talk about how estate and gift taxes work. This will be the most complicated thing we talk about. Again, if it's something that you need to worry about, you're lucky. You'll see what I mean in a minute. So suppose I died this week with an estate of $11.58 million. The tax on that estate would be $44.6 million. Wow, that's like 40% of it, right? That's pretty heavy tax. Here's the good news. In 2020, you have a tax credit on the federal estate tax. And tax credits are better than tax deductions because they reduce the tax due dollar for dollar. So a tax credit of 4.6 million should reduce a tax of 4.6 million to zero, right? So if I have an estate of 11.58 million, my estate taxes due should be zero. I have to say a little maybe there. It depends. Lawyers love that phrase. It depends. 'Cause that's where we end up making a lot of money when we tell people it depends. For reasons that might be obvious in a minute, the estate tax has to interact with the gift tax. If not, everybody would give away all their money on their deathbed to avoid estate taxes. So there's also something called a gift tax. And here's how the gift tax works. If I wanted to, if I could afford to, I could give everyone on this webinar a $15,000 gift today, and none of those gifts would be subject to the gift tax. I have an annual $15,000 exclusion from the gift tax per donee, per person that I want to give money away to. So I could give it to everybody at DePaul, I could give away to everybody on my block, 15,000 or less for each person. So suppose I did that and I decided to give Judge Hartigan that 15,000 today, and then tomorrow I gave him another $10,000. Can you see how the $10,000 would be a taxable gift? Because I've used up my $15,000 exemption for 2020. So I have a $10,000 taxable gift. The first time in my life I've ever made a taxable gift. Why is that important? Well, like the income tax, they stack it on top of one another, and the tax rate gets higher and higher. But the first time I did it, the tax rate is 18%. So theoretically, there's an $1,800 tax due. Would I have to file a gift tax return next April? Yes, I would. Would I have to write a check to the IRS for $1,800? No, because along with my estate tax credit, I also have a gift tax credit that allows me to make $11.58 million in taxable gifts during my lifetime. But any taxable gifts that I make during my lifetime are treated as if they're still in my bank account at my death. The way that works is I can give away $11.58 million either at my death or during my life, but not both. That's how the gift tax interacts with the estate tax. So I have an $11.58 million tax-free estate from federal taxes. There's also Illinois estate taxes that kick in at $4 million. When you combine Illinois and federal taxes, the rate gets up around 50%. So not many people are subject to estate and gift taxes, but if you are, it's a heavy tax. It's a very heavy tax. So you really want to do some planning. A couple of wrinkles about the estate taxes and gift taxes. All bets are off between spouses. You can give during your life and leave at your death an unlimited amount to your spouse, and none of those transfers of wealth will be subject to estate or gift taxes. The other is spouses can combine the $15,000 exemption from the gift tax. So I could give somebody $15,000. My wife could give that same person $15,000. We've just gotten $30,000 over to that person, gift tax free. And last but not least, spouses can combine that $11.58 million tax-free estate and give away a total of $23 million. So you can see the estate tax, the gift tax only affects pretty fabulously wealthy people, especially on the federal estate tax, but it's a heavy tax. And so if you have an estate tax issue, it behooves you to do some planning. If you don't have an estate tax issue, and I certainly don't, sorry about that, but then you really don't have to worry about gift taxes and estate taxes. They make such a big deal about it, especially around election time, but it affects less than 1% of our society. So for most of us, we don't have to worry about it. But if you do have to worry about it, go see a lawyer. It'll be well worth whatever you have to pay to minimize your estate taxes and gift taxes. So thanks for your patience there. That's the heaviest thing we'll cover. Charitable giving through your estate plan. It's something that I work on with people for the most effective way to include charity in their estate plan. For the vast majority of us, it's through our retirement assets. And the reason is this: most things that I leave to people will not be subject to income tax when they receive it. So I could leave Emily, who started us off tonight, $1 million, and Emily receives that, doesn't have to pay income tax on $1 million, because it's a gift. Most gifts aren't subject to income taxes, right? Um, there's a couple of big exceptions to that rule, and the biggest one is my retirement plan, not my Roth IRA, but my regular retirement plan. I've never paid income taxes on my retirement plan. If I leave my retirement plan to Emily, she has to pay income taxes when she takes that money out. It's a taxed burden asset that I leave at my death. That makes my retirement plan the best asset in my particular situation to leave to charity, because Emily, if she's in a 30% tax bracket, only keeps 70 cents on the dollar of the assets in my IRA. DePaul would keep $1 on the dollar. It's like having Uncle Sam chip in 30% of your gift. So very, very strongly recommend that you consider that for any charitable giving that you might do through your estate plan. Consider doing it through your retirement plan. Last but not least, I want to talk real quickly about your living will and your durable power of attorney for health care. Most lawyers will do this when they work with you to set up an estate plan. So what's a living will? A living will is a statement that under certain circumstances, if you no longer have brain activity and you have no chance of regaining it or surviving, you want attempts to preserve your life to stop. Then you have the power of attorney for healthcare. What is that? So a power of attorney gives someone the right to act on my behalf, right? A power of attorney for healthcare gives someone the power to act on my behalf for healthcare decisions if I'm unable to make my own healthcare decisions. And it ends up being the broader of the two documents. In other words, if I'm incapacitated, the person who's my power of attorney for healthcare can make my decisions for me. They won't even look at my living will. But you want both. You want the living will there as a fallback, just in case the person you've appointed as your power of attorney for healthcare isn't available. So very important to have these two documents just in case you need them. A little bit about taxes. This little quote from a judge, learned hand that we read about a lot in law school, basically says that there's nothing wrong with trying to minimize your taxes due. And I'm going to give you a couple of examples, although I might, since we're so late, I might skip the first example. Maybe I'll do it kind of quickly, about ways that you can make gifts to charity through your estate and get some tax advantages. And these are not tax dodges or tax ruses. They were set up by the IRS to encourage people to give to charity. And one of them is called a charitable remainder trust. So for this example, I say mom and dad, but it doesn't have to be a married couple. And let's suppose they have a taxable estate. They know they have a taxable estate. And one of their assets is some stock worth $300,000 that they only paid $30,000 for. And it pays them a low dividend of $3,000 a year. So it's gross stock. So they bought it a long time ago, or it's stock in his or her company, and it doesn't have a large basis. If they sell that stock, they'd have a $270,000 capital gain. Mom and dad have children that they'd like to leave their assets to, and for the most part, and their estate planning priorities are that they'd like to minimize estate taxes, keep the taxes as low as possible, nothing wrong with that. They'd like to leave an appropriate amount of their money to their son and their daughter, and they would like to do something, in this case, for DePaul and maybe some other veterans organizations. So a couple of options they have is they could sell the stock now. They feel like they don't like having that much in just one stock, but if they sell it, they get hit with a large capital gains tax. So they don't like that plan. And then I told you they have a taxable estate. Whatever's left after the sale will get hit with a 50% tax at their death. So that's not too appetizing. What if they don't sell the stock, they just hold on to it? Well, they don't like the fact that their assets aren't diversified. That's a lot of money to have in just one stock. And also, it'll get hit with the 50% tax at their death. And in neither of those scenarios have they done anything for the charities that they care about. So what if mom and dad instead contributed this money to a charitable remainder trust, and they instructed the trustee of that trust to sell those assets and reinvest those assets to diversify? The great thing about having it inside a charitable remainder trust is that when that happens, it won't trigger an immediate capital gains tax the way it would have had mom and dad sold those assets and diversified. Not only that, but their income from the asset will go up from 1% a year to 5% a year. So that'll go up 5 times, to $15,000 from $3,000. And mom and dad get a nice tax deduction for doing this, probably around $140,000, $135,000. Why don't they get a $300,000 tax deduction? Well, they are giving away $300,000 irrevocably, but they're reserving the right to receive 5% a year for the rest of their life. So that income stream to them has a value, and that's taken off the top for their tax deduction. So usually the tax deduction for this kind of trust comes in around 40% of the gift or so. So a very nice tax deduction, 6-figure tax deduction. So during their life, they get these great things. They get the ability to diversify without triggering an immediate capital gains tax. They get a nice tax deduction of $120,000 or $130,000. They increase their income by 5 times from that asset. And at the end of their life, if the trustee does a little better than 5% on the investments in the trust, that could be a nice chunk, $350,000 or more to go to DePaul. Great outcomes so far. During their life, they get a tax deduction and they get increased income and they get to diversify without triggering a big capital gains tax. At the end of their life, DePaul gets this gift that they want to make. What about son and daughter? Well, here's what they're going to do. They're going to use some of that $15,000 to fund a life insurance policy, but they don't want to own this policy in their own name, because if they own it in their own name at the end of their life, the proceeds from that policy will be taxable. So instead, they set up an irrevocable life insurance and they own the life insurance policy inside that trust, irrevocable life insurance trust. So during their life, like I said a few times before, they get a tax deduction, they get increased income, they get the ability to diversify. At the end of their life, they make a wonderful gift to DePaul, and the kids get from the insurance trust $300,000. They got a second to die policy for $300,000, and that's more than they would have gotten if they had been left that stock and it got hit with a 50% estate tax. So it really is a win-win here, and that sometimes happens in my work, that there's actually a win-win, that you can leave just as much or maybe even a little more to your family by doing some of these techniques. Now, a lot of people say, I like the idea of making a gift now, but getting an income for life, but I don't have $300,000 to invest in it. There's another way to do that called a charitable gift annuity. For this one, we have a guy who's 80 years old, and he has money in a CD, and it's about to come due. It's $100,000. And if he puts that back into a CD, I think he's going to have a hard time getting 1% return on that CD. But he's thinking he's going to leave that money to DePaul anyway. What he can do instead is he could set up a charitable gift annuity. He could make it for a scholarship fund for veterans at DePaul, and DePaul will pay him 6.5% a year for the rest of his life. Now that's a lot more than a CD. He's going to get $6,500 a year. A CD was only going to pay him 1%. Well, how can DePaul pay 6.5%? Well, think about it. When I do a CD, what do I get at the end of the CD term? I might get my 1%, but I'm also going to get my principal back. The way a gift annuity works is I get a lot higher rate of return, but at the end of the at the end of the term, which is the end of my life, DePaul keeps whatever principal is left, okay? And that annuity rate depends on your age. So the older you are, the higher the rate is, right? Because the shorter your life expectancy. Not only do you get that annuity rate of return, you also get a charitable deduction. And right now, this month, the charitable deduction would be $46,550. Right? It's similar to the remainder trust. You don't get a $100,000 tax deduction because you're keeping something. You're keeping the right to receive $6,500 a year for the rest of your life. But it's kind of the way for him, for this donor, to pull the trigger on his estate gift a little early and get some income for life. Not only that, but with gift annuities, if he funds it with cash, um, for 9 years, most of the 6,500 will be tax free. That's a pretty good deal. And after 9 years, it becomes taxable income. But lots of advantages to a gift annuity. You can fund it with a lot less money than you need to fund a remainder trust. You got to be of retirement age to do a gift annuity. We can't issue gift annuities to 40 and 50-year-olds. But if you're north of 60 or older, it's even better if you're a little older. You get a far better rate of return. This can be a good option for people. So last thing I want to talk to you about doesn't involve estate planning. It's just this opportunity that's available between now and the end of the year. And usually, if you at DePaul, if you wanted to create an endowed scholarship fund, you had to make a gift of $50,000. But from now until the end of the year, if you can commit to $25,000 and you can stretch that gift out over 5 years, you will be eligible for a match from the estate of Bill Hay of $25,000, bringing you up to that $50,000 minimum. Of course, you can always do a $50,000 gift, and the Bill Hay gift would bring it up to $75,000, or 100,000 would bring it up to $125,000. But the point is that there's a chance right now, between now and the end of this calendar year, to have a gift of $25,000 or more towards an endowed scholarship fund matched by $25,000 from the Hay estate. This is not about giving it through your estate plan. It's about an outright gift, but it can really, really work for some people. It's a little bit selling like hotcakes, so I don't know that we'll have them all the way to the end of the year. The matches might be all used up, but I wanted to mention that in case anyone's interested. It's actually something my wife and I took advantage of. We created an endowed fund and named it for my parents, who did not get to go to college. And one of the reasons I'm very proud to work at DePaul is our focus on first generation students and underserved populations. So that's all I got. I'm happy to answer any questions. What I recommend is that if you have questions, and you can put them in the chat function, that I'd be happy to answer those. Let's do general questions now. If you have detailed questions about your own personal situation, I want to say that we are here to help. My colleague Mary Anderson could not be here with us tonight at the last minute. She had to attend to a family situation, but she is also a lawyer, and she's been at this almost as long as I have. We are happy for no charge to answer your questions about your estate planning situation. You can email us. You can respond to a survey that will be going out to you after this presentation. But consider me a resource, and consider Mary a resource. We are happy to be now, a month from now, 5 years from now, to be a resource for you with your estate planning questions. And what we get paid by DePaul to do is to help you include DePaul in your estate plan. So we really love to talk to you about the possibility of making a gift to DePaul in your estate plan, if and only if that makes sense for your family. Also, by filling out that survey, you can request that we send you this estate inventory, which we're happy to do. We can email it to you or mail it to you. If we email it to you, you can print it out. So any general questions, I'm happy to answer. Otherwise, I'm happy to meet with you over the phone, on Zoom, or if you want to, safely in person, to talk about your estate plan. And you can request the meeting or the estate inventory by responding to the survey or by sending us an email. So that's being said, I went over a little bit. I know I went fast because we started a fair bit late, so I wanted to get it all in without keeping you from your dinners if you haven't eaten yet. But Emily, I don't know, I didn't see anything come in over the chat function, but maybe I missed something. Did you see any questions?
I haven't seen any questions so far, but again, if anybody has any questions right now that are more general questions, you can start typing them. And I think Judge Hardigan also wanted to pop back on quickly as well, just to say a few words. So Judge Hardigan, if you want to unmute yourself as well, while some folks are submitting their questions.
Can you hear me, Emily?
We can, yeah, you sound great.
Thank you, Rich. What a wonderful presentation. Especially helpful to look at the slides you had too. And it makes me think that I really need to take a look at this. My wife is shaking her head right now. But I did want to mention two things. One, it's very easy to get a power of attorney. I'm not trying to cut you out here, Rich. Those are pretty accessible on the internet, and certainly for medical reasons, they're very important, and especially if it's a do or die situation when somebody's in really a stressful health issue. The family needs to make a decision, and those are really things that need to be done beforehand, because otherwise it causes a lot of consternation, believe me. The second thing is land trust. Now, land trust, people put their real estate, their real property into a land trust. I represented a lot of policemen in my career, and they always feel that they may get sued, punitive damages or what have you, and they believe that putting their real estate into land trust prevents them from being sued. The answer to that is wrong. Because what happens is the summons will go towards, let's say, Chicago Title, and Chicago Title has the land trust, and they have to disclose who the beneficiaries of the land trust are. And a land trust actually does operate to a certain extent, a little bit like a will. If that's all you got is real estate, and a lot of us, that's really our main asset is real estate. You may consider a land trust. And be honest with you, my property is in a land trust. And of course, in the trust documents, it shows who the family members are entitled in case of your death. But it only applies to real estate. The other thing I wanted to mention is the executor, and Rich mentioned that too. Make sure that you have a competent executor. A lot of times fights occur over what the executor takes by way of fees in the processing of the estate. I've seen that happen. You can't necessarily limit the executor in their fees, but be careful that you trust the executor and that they're not going to overdo the billing on the estate. That's all really I have to offer. I really enjoyed, Emily, you're putting this together along with Derek and Shannon and Rich, of course. And by the way, I was in Bill Hayes' class in the MBA program. What a wonderful man. I'm not sure if he was single, married, whatever, but I do know that he devoted a lot of time to DePaul, and he did very well, obviously, in the finance area. But nonetheless, I found that to be very interesting. Bill was a very good instructor in the MBA program, and I had the privilege of being his student. But thank you all on my behalf, and I'll give it over to Emily.
Awesome. Well, thank you so much. I can take very little credit for this, as Rich is certainly the expert, and Derek and Shannon did much of the legwork. So I will we have one or two questions, Rich, if we still have time for those. Again, thank you all for hanging around a little bit later here. The first question is, you mentioned that about $2,000 is the average cost for estate planning in Illinois. And would you recommend doing this on your own, or and is it possible for you to set up, sorry, I read that question backwards. Is it possible for you to set up a trust on your own, and is that something that you would recommend, or is that something we should really leave for lawyers?
That's a great question. Couple of things on that. One thing is I did mention $2,000, but that was what the lawyer in the Chief Justice Berger article said he would have charged Chief Justice Berger to do a trust with tax planning back in 1995. So I don't think there is any average for an estate plan. It really depends upon your situation. And I guess I'm going to betray my biases here. I think it is important to have a lawyer put this together for you, and the reason is this: um, the there you first of all, it's perfectly legal to do your own will, and if you have it witnessed properly, you can do it on the back of a napkin, and it will be legal. And that's kind of what Chief Justice Berger did, right? He thought, oh, I'll just have my secretary type something up. And it was a little bit of a disaster. Um, so the reason, even if you don't have a tax situation, a lawyer will probe. Like I often will do some wills for friends, parents, and people at church.
Yeah.
And,
Okay, so
and I'm sorry, go ahead. Uh, and it's just I can probe a little bit. Like they want to leave every little thing in their house to somebody, and I could say, well, that could get really expensive because your lawyer then, if it's in the will, they got to find that person. If that person's moved to Australia, they got to, and that's going to take the lawyer some hours to do. Well, could you ever just give your executor the power to give away your personal property and then leave a note to your executor outside your will? Um, there's little things that people aren't aware of that can happen in probate, that can happen in estate, in wrapping up an estate, that an experienced lawyer can probe and make sure what's important to you happens, and it doesn't happen in an unduly expensive or work intense way. I can't do folks' wills who I meet on these seminars just because I work for DePaul and I'd have a conflict of interest. But I can recommend lawyers that I know. Before I did that, I'd want to talk to you about your personal situation and where you are. But I can help you find a lawyer. But the price range for lawyers is a little all over the map. So you always want to, like anything else, you want to call two, better three, and get their prices and see how you like them and how you connect with them. So I hope that answers the question.
Great. One other question we saw was, is there a minimum amount or minimum assets that you need in order to start a trust?
No, there isn't, but you'd want to ask yourself, a trust is going to be more expensive to set up than a will, like by 1,000 or two, like not just $100 more. So you're going to ask yourself, is the advantages of having a trust worth it, worth that extra money? Certainly, if your assets, when you total them all up, are less than $100,000, the estate's not going to go through probate anyway. Less than 100,000 with no real estate in Illinois, the estate's not going to go through probate anyway. I wouldn't go to all the trouble to put together a revocable living trust in that situation. Um, and even, just a little bias of mine that will become apparent. I don't have a revocable living trust. Not that I don't like them. Like I said, I put one together for my dad, but it doesn't seem necessary to me. I'm really, leaving some of my retirement assets to charity, but that won't go through my will anyway. That will go directly to the beneficiaries. My estate is going split evenly between my kids. That's not going to get contested in probate, so I'm not worried about probate. So it's not that there's a minimum, it's more you want to do a little evaluation. Is it worth the upfront investment? And it very well may be, to have a revocable living trust. And I'm happy to talk about people's individual situations with whether a trust makes sense.
Perfect. Well, we're coming up on 7:15 here, so maybe we'll just take one more and wrap it up. One question was, what is the difference between a revocable and an irrevocable trust?
That's an excellent question. A revocable trust means you can change your mind at any time, and you can take the money back out of that trust, and you can do anything you want. When you put money in an irrevocable trust, That money's in that trust to stay. You can't take that money back, no strings attached. So why would you put money in an irrevocable trust? You wouldn't unless you had to. And the reason you would have to is probably has to do with taxes. Like in other words, unless a charitable trust is irrevocable, you don't get a tax deduction, right? If it has a string and you can pull it back, you're not going to get a deduction for that. Um, and also, sometimes people want to give gifts to family members in trust now so that none of that growth over the years is subject to taxes. They'd rather pay a tax on the gift now when the value is a little lower and then let it grow, and that growth avoids the taxes. Well, the only way that's going to happen is that if that's an irrevocable trust. The bottom line is, unless you have a whole lot of money, you're going to do revocable trusts. You're only going to do an irrevocable trust if it serves you, usually from a tax standpoint. I have a trust set up in my will that if I die while my kids are minors, that money goes into trust for them. That trust doesn't even exist until I die. But once I die, that becomes an irrevocable trust. That money goes in there and it has to be used for the kids' benefit. Nobody can take it out and do anything else with it. So I hope that answers the question. That's kind of the difference between an irrevocable trust and a revocable trust.
Yeah, that was definitely very helpful. Awesome. Well, I think that is going to wrap it up for us this evening. As Rich shared, we will be sending out a post-event email tomorrow, so be sure to keep an eye on your inbox. And if you have any questions, if you want to request a copy of the estate planning inventory sheet, if you have questions for Rich, and he mentioned Mary isn't able to be here tonight, you can also request that they follow up with you through the survey. So basically it's kind of a one-stop shop of all you need to know, but of course Rich and Mary both shared their emails here. So again, thank you all for joining us this evening. Thank you to Rich for sharing so much of his expertise, and of course Judge Hardigan as well for sharing some of his knowledge and joining us for this webinar. And of course, thank you all for your service and for everything that you've done for our country and our communities. So yeah, we will wrap it up now, but thank you for joining us and have a great rest of your evening.
Thanks, everybody.
Thank you.